Welcome to MF Garza Law Firm, helping injured victims, one Texan at a time.
Hello and welcome back to MF Garza Law Firm, helping injured victims one Texan at a time with Miguel Garza. Miguel is the founder of the MF Garza Law Firm, where he fights for Texans injured in accidents ranging from car and trucking crashes to catastrophic injuries. I'm Leanne Lyon, and today we are talking about multi-car accidents in Texas and how fault, insurance coverage, and financial responsibility are sorted out after a chain reaction crash. It's good to see you again, Miguel.
Good to see you. Good to be here.
Miguel, in a multi-vehicle crash, what is the first step in determining how fault is divided under Texas law?
Well, without going to a trial, the simplest way to kind of determine that in the earlier stages of the case is usually by a crash report that's drafted by the local law enforcement agency. Police officers typically do a good job of acquiring all the information like the parties, people involved, the make and model of the vehicles, and get witness statements as far as how, what the accounts were of everybody that was present at the scene. And then based on the officer's investigation and observations, they provide an opinion of who may be at fault. Every police officer is going to say, we don't determine fault, we just take the information provided and then we put it in a report. Any officer is going to tell you that unless they actually witness the wreck, right? But someone that, they basically give you an opinion is like, did someone run a red light? Did someone fail to use the right of way? Things of that nature. But probably the best way to determine who's at fault is by speaking to the witnesses firsthand yourself and obtain their version of how the wreck occurred. Because in most cases, if a police officer didn't observe the wreck, his or her crash report is not going to be admissible at trial. So you have to rely on eyewitnesses to explain to the jury who may be at fault. Also, property damage is extremely important too, because it'll help explain, how the wreck occurred and the points of impact, right? Was it a rear end collision? We all know that the person that rear ends somebody is usually at fault for the wreck unless there's some crazy reason why they're not. Was it a T-bone collision where someone may have run a red light? Did one of the drivers say something at the scene where they admitted fault? Did they admit that they were, at a bar before and they had some drinks beforehand? Or, did they not get any sleep and their eyes were, bloodshot red and they just looked extremely exhausted? So a lot of things like that they're taken into consideration, but usually the crash report is the first thing that all parties try to collect because it has a majority of the information that's relevant to the case.
So how does the Texas comparative fault system apply when 3 or 4 drivers may have contributed to the collision?
Well, at the end of a trial, the jury will have to fill out what's called the jury charge, right? And the jury charge, if let's just say there's 4 people involved in a wreck, there will be a blank for each person involved in that wreck, and the jury has to decide the percentage of fault and negligence for each person involved. So, and basically, all that will be based on the evidence presented at trial. Did the jury find one party to be more credible than the other? Does the evidence, like property damage, match up to what one party said over another? It depends on the facts, right? Like I said, all lawyers are going to tell you it really depends. But in that case, if there's 4 people involved in a wreck and, the jury determines that 2 of the drivers are each 50% responsible, then those 2 drivers will be responsible for the judgment and have to pay out the damages to the person that filed the lawsuit. And the other 2 drivers that the jury did not place a percentage of negligence on or responsibility on will not be responsible for anything in that situation.
So in these cases, how do insurance policies stack or interact when multiple drivers do carry usually different coverage limits?
Depends on the percentage of fault for the specific driver from a wreck, right? If, let's just say, driver A only has a $30,000 minimum policy, which is the state minimum policy in Texas, and there's $100,000 in medical bills, then you might have to tap into your own policy called an underinsured motorist policy, which is nice to have in such a case when the at-fault driver is underinsured, like in that scenario I just presented, because if in that case, the insurance company would step in, your own insurance company, to help out and help you recover the remaining $70,000 in bills since driver A was underinsured. So Texas allows stacking of policies, meaning that you have access to the liability policy for the person that was at fault and your own underinsured motorist policy. States like California do not allow you to stack such insurance policies, which can be extremely problematic. So at least in Texas, it's good to have that extra layer of coverage, and how stacking policies can benefit you to help get all of your medical bills and damages paid.
So, when commercial vehicles or company drivers are involved in a chain reaction crash, how does that change the liability analysis?
Generally speaking, a commercial vehicle can weigh significantly more than a typical family vehicle like a sedan, right? And in such cases, like an 18-wheeler, for example, they can weigh up to 80,000 pounds. That's more than a modern tank nowadays. So if you can imagine, the damage from a wreck involving an 18-wheeler would be much more severe than a regular car crash involving two sedans. The more weight and the more speed as a commercial vehicle travels can equal a very high velocity, also known as what's called the delta V, is what some engineers and physicians will refer to for the point of impact, which can cause very severe damage. It also depends on the type of damages someone sustained in that chain reaction crash, right? Also determining if the driver complied with company guidelines, were they using their phone? Did the company do a thorough background search when they were hiring this driver? Did they properly drug test or do an alcohol test of this driver before and after the wreck? And then, of course, did they properly hire, train, and supervise this driver? Because if there's other prior wrecks for this driver, and he's basically kind of a ticking time bomb, so to speak, and a very big risk to the company, but they keep him on to basically put profits over safety, then that's going to be a big no-no to the jury, and be basically what I like to call a piss-off factor, saying that this company should have fired this driver. He has a bad record. He should have never been hired, and he should have actually fired him after his previous wrecks while in the scope of employment with the company. So things like that need to be taken into consideration when determining liability and percentage of fault.
So, what kind of evidence becomes critical in reconstructing the sequence of events in a multi-car accident?
So things like the downloading data. So most vehicles have what's called an ECM module, also known as like the black box, where you can download data from the vehicle, and it shows various things like the speed somebody was traveling, the direction they were traveling, the whether or not they were braking at the time, or whether or not they actually were accelerating at the time as well. And a number of things can be retrieved from the black box data to tell what a person was doing at that time, right? Another thing is also can be determined is like, was this person actually paying attention to the roadway? Were they reckless and maybe looking at their phone, and when they should have been paying attention to driving? Wide range of factors can be considered, and those are just some of the significant ones. Downloading data from drivers' cell phones is a big one as well, and can be very important because I had an 18-wheeler wreck where somebody was alleged to have been on their phone, and we downloaded the data from their phone, and it turns out that they were actually watching a YouTube video at the time of the wreck, and he caused a 4-car collision on a big interstate in Texas, and it shut down the roadway for over 5 hours. And just because this truck driver was bored watching a movie while behind the wheel of a 80,000-pound vehicle. So a lot of things, and also dash cam videos or body cam videos from the trucks or the investigating law enforcement agency can be very important as well.
Wow, that's amazing. Can you walk us through a case where determining who caused the initial impact was even more complicated than it appeared at first glance?
I'd say the most common one would be like a 4-car rear end collision. Basically, one hits the car in front of them, and then that hits the person in front of them, and so on and so forth, right? So the big thing is that type of accident usually happens when it's in a rush hour, or there's a lot of traffic going on, stop and go traffic, right? So one of the biggest things is determining is whether or not one of those, the first vehicle that caused it is number one, and then 2, 3, and 4. Let's just say that maybe the vehicle number 3 had bumped vehicle number 4, and then because they slammed on their brakes and bumped number 4, that caused number 2 to hit them, and then it caused number 1 to hit them. So you would think the first vehicle, number one, would be responsible in that case, but it was actually the third vehicle in that chain reaction. So, and in that situation, you got to get the statements from every single driver. For example, did one driver feel more than one impact from the rear? And if so, then they're probably a contributing factor to that case because they weren't paying attention. So really depends on how many vehicles were involved and getting the accounts of all the witnesses and the drivers involved in that situation to find out how many impacts occurred and what exactly was happening at that time.
So, how does sudden stops, brake checking, or weather conditions factor into fault allocations in these scenarios?
There's a common defense that defense attorneys or insurance companies like to use, and that's called a sudden emergency defense. Basically, that the sudden brake check was so sudden that nobody could have predicted it, and they were so close that they couldn't stop in time. I mean, that's just nonsense. Everybody's supposed to maintain a certain amount of distance depending on the speed that they're going behind when traveling behind a vehicle. That's one that they try to use. Weather conditions is probably the most significant because obviously you're traveling in wet or icy conditions. You have to have the self-awareness to, or common sense rather, that you are not going to be able to stop as quickly or as suddenly as needed in such conditions. If somebody does brake suddenly, or something falls from the sky, whatever the case may be, right? Or a dog runs out in the middle of the road. That's why you need to keep your driver attention at that time and make sure that you're not going to go and collide and hit any of these objects, just in case something like that happens. It's called defensive driving, and that's something that we all have to do. But one of the things is that you really just need to be aware of the conditions that you're traveling in and make sure that you're driving as safe as possible in such a situation.
So, when insurance carriers begin pointing fingers at each other, what strategic challenges does that create in resolving the case?
It depends on what type of lawyer you want to retain because, one person at the scene may say that they're responsible for the wreck and they're accepting fault. But then when everybody leaves the scene and goes home and the next day they go and tell their insurance company, no, it wasn't my fault. It was this other driver, even though they may have said something completely different to you the day before. Happens all the time. And so, that's what they try to do. Insurance companies are going to try to find any way out to not pay a claim. All right. They're racking in billions of dollars every year and not paying claims out like they should and basically forcing attorneys like myself to go and file a lawsuit. Quite frankly, if I see that there's a certain insurance company that might be involved in a case, I'm aggressive. I'm just going to file a lawsuit because I'm not going to deal with their nonsense. And I don't want to waste time. I don't want to waste my client's time. And you know what? You want to go and point the finger at somebody else? Let's go to court. Go and tell a jury that. Go and point the finger in front of the judge, and let's see if that holds up in court. Because generally when that happens is when they tend to accept responsibility or fault, and then they pay out on the case. If you don't want to file a lawsuit or you choose to hire a lawyer that tends not to be as aggressive, you might have to accept a lower offer and, not be so happy about the resolution of your case. So sometimes it's just better to hire somebody that's aggressive and willing to go to court and hold the insurance company's feet to the fire.
Well, as we wrap up for today, and from a litigation standpoint, what makes multi-car accidents significantly more complex than a two-vehicle crash?
Evidence, like I said, sometimes evidence may be lost. For example, like somebody might get their vehicle fixed before pictures or video can be obtained. Somebody may, like I said, say instead of just getting one person's statement, you got to get 3 or 4 or 5 people's statements, right? And so just obtaining that information, because some people don't want to be bothered, right? They got families, they got their own lives, they got to work, make a living. They don't want to deal with something like this, especially if it's a minor collision. But, in the insurance companies in such cases have to conduct their own investigation. And that means speaking to all parties. So if they can't get a hold of one particular party, then they just might say that we can't accept responsibility at this time because our investigation is still pending, and they're not going to accept liability and pay out on the claim because of that one witness or that one party. So insurance companies will, like I said, find any excuse for the most part to not pay out on a claim. Now, some insurance companies might, just to get it resolved and try to be done with it, but some of these not so reputable insurance companies will find any reason not to pay it out. And that situation, it might require a lawsuit in order to find out more information, because once I file a lawsuit, I can start issuing subpoenas, I can get court orders, and then I can find out more information that way. And I'm not just waiting at the convenience or at the mercy of some insurance company who's more than likely not going to pay out something that my client needs to get a proper resolution and proper compensation.
Well, that is it for today's episode of MF Garza Law Firm, helping injured victims one Texan at a time. If you'd like to learn more about Miguel Garza and how he handles complex accidental cases across Texas, visit mfgarzalaw.com. And remember to like, leave a review, and subscribe to the show so you catch the next episode. Thank you, Miguel.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.